Welcome, dear students. Today, our topic of deliberation is marriage and matrimonial rights. Dear students, in order to understand the nature and essentials of marriage, one should know the essentials of marriage and its effects. In this lecture, we will discuss the following areas of Muslim marriage. 1. Forms of marriage, its legal requirements. 2. Classification of marriage. 3. Legal effects of valid marriage. 4. Enforcement of conditions of marriage. 5. Restitution of conjugal rights. 6. Mutta marriage. To make a Muslim marriage valid, the following essentials are necessary, and without following them, the Muslim marriage will not be valid. The legal requirements of a Muslim marriage are: number 1, ijab; number 2, qabul; number 3, vilayat; number 4, wakalat; and finally, gawahi. Let's talk about ijab, that is proposal. The intended marriage between two persons should first be proposed by or on behalf of either party. This is called ijab. Number 2, qabul or acceptance. The proposal so made should be accepted by or on behalf of the other party to the intended marriage. This is called qabul. Number 3, form of ijab and qabul. The expressions conveying ijab or qabul must be reasonably certain so as to result into a completed transaction. They must not convey a mere intention or promise to marry. Number 4, vilayat, that is guardianship. As regards those who are not competent to contract their own marriage, ijab or qabul, as the case may be, is to be made by their marriage guardians called wali. In Shafi and Ismaili laws of marriage, guardian is also to act on behalf of a girl who has attained puberty, unless it is not her first marriage. In Hanafi law, a woman who has attained puberty can act, if she so desires, through a marriage guardian. Number 5, wakalat, that is representation. Those who are competent to contract their own marriage can make ijab or qabul either personally or through a representative, that is a wakil. Number 6, gawahi, that is witness. Witnesses needed for a marriage are 2 males or 1 male and 2 females. Under Hanafi, Shafi and Ismaili laws, ijab and qabul should be made in the presence and hearing of witnesses, that is gawah, who must be Muslim and competent to contract their own marriage. In Hanafi's law, there must be at least 2 female witnesses. Absence of witnesses will render the marriage irregular in Hanafi law. Under Ithna Ashari law, presence of witnesses is not legally required at the time of the marriage. 7. Majlis-e Wahid, that is single sitting. Ijab and qabul cannot be made in separate sittings, but in one. Ijab and qabul are to be made in a single sitting, signifying continuity of transaction. Ijab, when followed by qabul, results into a marriage contract. Thus, above mentioned requirements are essential for a Muslim marriage. No other formality is necessary. It is a wrong notion to believe that there are any specific ceremonies of a Muslim marriage feast or any other rites or rituals on the occasion of marriage are merely customary. It is nothing to do with the legal validity of marriage. The Delhi High Court in one case decided the validity of conversion of religious faith of the parties to the marriage and nikah. In Fahim Ahmed versus Navia Lakshmi, the twin problem before the court was whether there was a valid conversion. In this case, the petitioner had converted from Hinduism to Islam, and the High Court had to determine the status of the marriage solemnized after conversion. The case of the petitioner was that she wanted to get the membership of library in the Jamia Masjid, Delhi. The respondent deposed that she signed and executed certain documents which the appellant claimed to be the registration of the marriage and convergence certificate, and that by virtue of those documents she became his wife. High Court held that it should not be an exercise undertaken by someone as a mere pretense to achieve some mere limited objectives or purpose like entering into matrimonial contract. The High Court further held that since there was no conversion of the respondent from Hinduism to Islam, and thus there could not have been any valid marriage between the parties, as the marriage of a Muslim with a non-Muslim is invalid in itself. The High Court observed that all the other contentions relating to the valid marriage according to Muslim rites and customs were found to be devoid of any merit. The court further laid down that even assuming that there was a void conversion of the respondent, the putative marriage lacked all essential requirements for a valid marriage under Muslim law, like offer, acceptance, two male witnesses, and free consent, etc. The Nikahnama itself did not indicate a requisite marriage. It is a testimony for a fact which had not been proved in the instant case. Therefore, the High Court held there was no valid marriage subsisting between the litigants. Let's move on to the classification of marriage. Three kinds of marriage are recognized by Muslim law. Islamic law provides certain legal requirements for the solemnization of marriage. Also, marriage with certain persons is allowed and with some others it is disallowed. On the basis of the fulfillment of these requirements, marriage under Muslim law have been classified into three classes. 1. Valid, that is Sahih. 2. Void, that is Batil. 3. Irregular, that is Fasid. We will consider each class with legal effects. Number 1. Valid marriages. A marriage which conforms in all with the law is termed as Sahih, that is correct. For a marriage to be valid, it is necessary that there should be no prohibitions affecting the parties. Now, prohibitions may be perpetual or temporary. If the prohibition is perpetual, the marriage is void. If it is temporary, the marriage is irregular. Number 2, void marriages. The issues of void marriages are not legitimate. A marriage which has no legal results is termed batil or void. A marriage forbidden by the rules of blood relationship, affinity or fosterage and some other prohibited marriages are void. The issue of a void marriage is illegitimate. A void marriage being unlawful produces no mutual rights and obligations between the parties. Illegality of such unions commences from the date when the contract are entered into and the marriage is considered as totally non-existing in fact as well as in law. Number 3, irregular marriages. A marriage is irregular when there is no permanent bar to the marriage. A union between a man and a woman may either be lawful or unlawful. Unlawfulness may be either absolute or relative. If the unlawfulness is absolute, the marriage is void. If it is relative, we have an irregular marriage. The following marriages have been considered irregular. Number 1, a marriage without witnesses. Number 2, a marriage with a woman undergoing iddat. Number 3, a marriage prohibited by reasons of difference of religion. Number 4, a marriage contrary to the rules of unlawful conjunction. Number 5, a marriage with a fifth wife. The Itna Ansari and the Ismaili schools of law do not recognize this distinction between void and irregular marriages. They treat a marriage either valid or void. The above mentioned marriages before them will be void. Let's now look at the effects of an irregular union. It is very essential to learn the effects of irregular marriage on the relations of the couple. This can be explained as follows. Number 1, as to the separation. It is the duty of the Qazi to separate the spouses, but either party may terminate the union also at any time. Neither divorce nor intervention of a court is necessary. One of them may say, I have relinquished you, and the unholy alliance ends. 2. As to the consummation. If there has been consummation, the wife is entitled to dower, proper or specified, whichever is less, and she must observe iddat for 3 courses. Number 3. As to the inheritance. No rights of inheritance are created between the husband and the wife by an irregular marriage. 4. As to the issue. The issues are treated as legitimate and are entitled to a share of inheritance. The legal effects of a valid marriage. As soon as the legal contract is established, consequences follow from it as provided by the Muslim law. It legalizes the enjoyment of either the spouses with the other in the manner which in this matter is permitted by the law. It also subjects the wife to the power of restraint of husband, as well as she becomes entitled to certain rights and privileges. It renders her dower and maintenance obligatory on the husband. A valid marriage establishes on both sides the prohibitions of affinity and rights of inheritance, and the obligatoriness of justness between the wives and their rights. On the wife, it imposes submission to the husband when summoned to the court, and confers on him the power of correction when she is disobedient. Further, it enjoins upon him associating familiarity with her and kindness and courtesy. It renders unlawful the conjunction of 2 sisters and those who fall under same category. The effects of a valid marriage may be summarized as under. Number 1, the sexual intercourse becomes lawful. Number 2, the children born of the union are legitimate. Number 3, the wife becomes entitled to dower. Number 4, the wife becomes entitled to maintenance. Number 5, the husband becomes entitled to restrain the wife's movement in a reasonable manner and to exercise marital authority. Number 6, mutual rights of inheritance are established. Number 7, the prohibition on the basis of affinity come into operation. Number 8, observance of iddat becomes necessary if the marriage is dissolved by death or divorce. Number 9, any agreement between the spouses becomes enforceable so far they are not inconsistent with the provisions and policy of law. Number 10, individual existence of the spouses remains unaffected. Let's move on to the restitution of conjugal rights. Restitution of conjugal rights is what when one of the spouses leaves another without reason, the other can file a suit for the restitution of conjugal rights. We know that most important obligation arising out of marriage is consortium, which not only means living together but implies a union of fortunes. A fundamental principle of matrimonial law is that one spouse is entitled to the society and comfort of the other. Thus, where a wife without lawful cause refuses to live with her husband, the husband is entitled to sue for restitution of conjugal rights. And similarly, the wife has a right to demand the fulfillment by the husband of his marital duties. The right, however, is not absolute. The Quran enjoins husbands to retain their wives with kindness or to part with them with an equal consideration. The court may grant restitution subject to certain specified conditions. Where a husband claims restitution of conjugal rights against the wife who has withdrawn from the former society, some of the valid defences are available to the later. Existence of a lawful marriage between the parties to a suit for restitution of conjugal rights is a condition precedent to the grant of desired relief. So, where it is proved that their marriage is void, the remedy cannot be granted. Also, the remedy cannot be granted in case of irregular marriage, even if it has been consummated, where the husband has not paid the prompt mahr of the wife while the marriage is yet to consummate, he cannot ask for decree of restitution. The case at hand, Itwari versus Shrimati Asghari and others. In this case, it was held that in a suit for restitution of conjugal rights by a Muslim husband against the first wife after he has married second wife, if the court after review of the evidence feels that the circumstances reveal that in taking a second wife, the husband has been guilty of such conduct as to make it inequitable for the court to compel the first wife to live with him, it will refuse relief. Sakira Banu versus Ghulam Mustafa. In this case, it was held that in husband's suit for restitution of conjugal rights, wife's evidence does not require corroboration. There is no rule of matrimonial law that even in a husband's suit for restitution of conjugal rights, the wife's evidence requires corroboration. Regular beatings by the husband after taking liquor, administering a glass of pesticides with intention to kill her, pouring kerosene over her to burn her, teasing her and ill-treating her for the mistakes that can be pardoned, or continuous ill-treatment can also attract the application of section 498A of the IPC to send the erring husband to jail. Bomindi Rajamulla versus State of AP and Clarence Pice versus Union of India. A decree of restitution of conjugal right is a proof of unreasonable withdrawal by a spouse. Thus, in such cases where a husband secures a decree of restitution of conjugal rights against the wife's petition filed subsequent to the grant of the decree will meet with failure. Even during the pendency of the review petition filed against the order of granting maintenance to the wife, if the decree of restitution of conjugal rights was passed against the wife by civil court, it would be open for the husband to bring the varied circumstances to the notice of the court which passed the award of maintenance and seek its cancellation. Similarly, where the wife lives voluntarily with her mother and despite the passing of a decree of restitution of conjugal rights in favor of the husband as against her, refuses to comply with the decree, lately denying cohabitation without any reason, the order passed by the trial court granting interim maintenance to her is not proper and rightfully set aside by the High Court. However, the Kerala High Court in Hezaz Pasha versus Gulzar Banu held that an ex parte decree of restitution of conjugal rights obtained by husband is not a bar to the consideration of petition of maintenance filed by the wife under section 125 of the CRPC. Now let's look at cruelty as a defense against restitution. Where a husband who has treated the wife with cruelty afterwards claims restitution of conjugal rights against her while she has withdrawn from his company, the court may not oblige him. As regards the test of cruelty, in the case of Munshi Bazlor Rahim versus Shamsunisa Begum, the Privy Council had held that there could be no special concept of Muslim cruelty, and in the case of a Muslim too, as in all other cases, the test of cruelty should be based on universal and humanitarian standards. This ruling has guided various Indian courts, which have in different cases regarded the following as instances of cruelty on the part of the husband. 1. Actual violence of such a character as to endanger personal health and safety of the wife. Number 2. Reasonable apprehension of such violence. Number 3. Misconduct. Number 4. Gross failure to comply with the conditions in marriage contract or clear breach of such condition. Number 5. Unfounded accusation of adultery. Number 6. Blasphemy. Number 7. Keeping a mistress. Number 8. Bigamy. However, it may be pointed out that as regards cruelty, the explanation of cruelty given by the legislature in section 2 of the Dissolution of Muslim Marriages Act 1939 should now guide the court in applying the test of cruelty. Lastly, it may be made clear that in law a Muslim wife too can get her conjugal rights enforced by means of a decree of restitution. In Sheikh Abdullah versus Hussain Ara Parveen, the High Court of Bombay was called upon to clear the doubts relating to restitution of conjugal rights. The court laid down that two queries must be answered in deciding this controversy, namely, whether there existed valid marriage in accordance with Muslim law between the appellant and the respondent, and whether the respondent had withdrawn from the society of the petitioner without reasonable cause. The present appeal was filed by the petitioner husband against the judgment and order passed by the family court dismissing his petition for restitution of conjugal rights. The High Court held that under Muslim law, marriage was a civil contract and all the ingredients of a valid contract must be satisfied. The court was of the view that the proposal in presence and hearing of the witnesses and unqualified and absolute acceptance of the said proposal at the same meeting can constitute a valid nikah under Muslim personal law. Free consent of the respondent and or the appellant was a sine qua non for a valid marriage. Considering the evidence on record, the High Court concluded that the claim of the appellant was not corroborated by any satisfactory proof as to valid nikah as well as to cohabitation and consummation of marriage as claimed. The court laid down that in order to succeed in a petition for restitution of conjugal rights, it was obligatory upon the appellant to prove the existence of a valid marriage between him and the respondent. The court in the above cases tried to decide the issues under the orbit of Islamic law in its true spirit, including the conversion from one faith to another, which indeed should be taken into consideration after having analyzed all the situations of pre and post status of the parties who have been converted. The conversion should not be only for the purposes of the marriage. Let us have a look on a particular form of marriage known as mutta. One more type of marriage is mutta marriage. This is a temporary form of marriage and is recognized only by Ithna Ashari school. Before we consider its nature, it is to be made clear that all of the schools of law, excepting one sub-school of Shia school, none of the schools grant recognition to this form of marriage. It is only the Ithna Ashari school in which it is permissible, and even amongst the Ithna Ashari of India, it is now obsolete. The word mutta literally means enjoyment, and mutta marriage is termed as marriage for pleasure. It is a marriage for a fixed period for a certain reward paid to the woman. Institution of mutta was fairly common in pre-Islamic Arabia, but the Holy Prophet, peace be upon him, finally declared such unions as unlawful. The number of wives that can be taken into mutta marriage is unlimited. The ceiling of 4 wives does not apply here. A Shia male can contract mutta with a Muslim, Christian, Jewish or Parsi, that is fire worshipper woman, but not with a woman following any other religion. A woman may not contract mutta with a non-Muslim. The amount of dower must be specified in a contract of mutta, otherwise the agreement is void. The child born of a mutta marriage is legitimate and capable of inheriting from the father. But in the absence of an express agreement, neither party to the mutta is entitled to inherit from the other. Maintenance is not due to the mutta wife unless it has been expressly agreed upon. Essential requirements of mutta. From the above, we can see that 2 main conditions of mutta are number 1, period, number 2, dower. As to the period, mutta being a temporary marriage is essence, it is necessary that the mutta contract must specify the period of the enjoyment. The fixed period can again be extended by a new contract. It can also be presumed to be extended unless disapproved. For example, in Shoharat Singh versus Jafri Bibi, A and B continued to live together without entering into a new contract. Living like this, a child is born to them in the 4th year. The husband dies in the 5th year. It will be presumed that the mutta had lasted for 5 years and the child was legitimate. In Shehzada Qanun versus Fakhr Jung, suppose A and B contracted a mutta marriage for number 1, unspecified time, that is, mention of period is omitted intentionally or unintentionally, or number 2, specified for lifetime. The question arises whether such contracts result in mutta or nikah. According to a decision by the Hyderabad High Court, in both cases a permanent nikah will result. Faizi does not agree with this. As to the second, he says that fixation of a period in marriage contract destroys the concept of nikah as understood in Islamic law. As to the first, in his opinion, the deciding factor should be the intention of the parties rather than the form of the words. The Privy Council had also held in Shorabat Singh case that where cohabitation of a man and a woman commenced with the mutta and there was no evidence as to the term of the marriage, the proper inference, unless disapproved, would be that mutta continued during the whole period of cohabitation. As to dower, mutta being a short-term contract, the element of dower is rightly emphasized. The dower must be specified, otherwise the contract is void. The wife's right to dower arises as soon as the marriage is consummated. She can claim the whole amount. But if she chooses to abandon the husband before the end of the fixed period, she must suffer a proportionate cut in the dower. According to Ithna Ashari and Shia law, a mutta is a marriage for a fixed period of time. It may be for a day, a month, a year, or a term of years. The essentials of such a union are four: the form, the subject, the period, and the dower. Mutta can be contracted with fire worshipper. As regards the form, there must be a proper contract. Declaration and acceptance are necessary. As regards the subject, a man may contract a mutta with a Muslim, Christian, a Jewish, or a fire worshipper movement, but not with the follower of any other religion. A Shia woman may not contract a mutta with a non-Muslim. Relations prohibited by affinity are also unlawful in temporary marriages. A man may contract mutta with any number of women. As regards the term of mutta, this must be specified, else a lifelong mutta will be presumed if the original cohabitation commenced with a lawful mutta. Mutta terminates on the expiry of the term specified. A mutta terminates by the efflux of time or by death. On the expiry of the term, no divorce is needed. During this period, the husband has no right to divorce the wife, but the husband may make a gift of the term and thereby terminate the contract without the wife's consent. Dower is necessary in mutta. The dower is a necessary condition of such a marriage. If it is not specified, the agreement is void. Where the marriage is consummated, the wife is entitled to the whole amount, if not to half the dower. On the expiry of the period where there has been cohabitation, a short iddat of 2 courses is prescribed. Where there has been no consummation, no iddat is necessary. The issues of a mutta union are legitimate and entitled to inherent end. In the absence of such specified agreement, the spouses do not inherit from each other. But if there is such a stipulation, it will be effective. However, mutta wife is not entitled to maintenance. Now let's look at polygamy in Islam. It is generally regarded that Muslims are freely allowed by their religion to contract 4 marriages at a time and then generally do so to satisfy their lust. It is submitted that nothing could be more erroneous than this. Neither Islam favors polygamy nor the Muslims prefer polygamous unions. In Islam, monogamy is a general rule while polygamy is only an exception. The Quran commands, marry such women as seems good to you, 2, 3 or 4. But if you fear that you cannot do justice between them, then marry only one. This is so that you may not deviate from the right path. To invoke the above verses as an unrestricted license for continuing the institution of polygamous marriages is contrary to the spirit of the Quran. An examination of the Quranic verses reveals that highly restrictive nature of polygamy with the Sharia. As Barlas in 2002 argued that permissibility to engage in polygamous marriages serves a very specific purpose, that of securing justice for female orphans. The Quranic ideal clearly is to establish monogamous union which is also affirmed in Surah Al-Nisa, whereby the Quran notes, "You cannot keep perfect balance emotionally between your wives, however much you desire it." Furthermore, the context in which the above mentioned Quranic verse were revealed also demonstrates their pragmatic nature. The divine ordinance was revealed to the Prophet, peace be upon him, in the aftermath of the Battle of Uhud, 625 AD, which had resulted in the loss of many male warriors, leaving scores of young women widowed and children orphaned. Polygamy as an institution could arguably serve to protect those women who would otherwise be condemned, discarded, or abandoned in the society through the operation on divorce or nullity laws. The High Court of Kerala, in an attempt to seek the meaning and concept of equitable treatment in accordance with the injunctions of Quran, in Abdur Rahim versus Khairun Nisa, travelled a long distance and took pains to find out the validity of polygamous marriages in Islamic jurisprudence. The court reviewed the purpose of marriage, Quranic restraints imposed on the polygamy, and the need of the polygamous marriages at different points of time. The court held, an attempt to understand Islamic law cannot be undertaken without understanding the core concept of Islam, that marriage is an institution to facilitate enjoyment of life, and if the institution does not cater to the enjoyment of life, the parties have the option to walk out of the same. The court conceded that Islam permits polygamy with inbuilt restraints. It quoted verse 3 and verse 129 of Surah 4 of the Quran and took help of the exegesis provided in Abdullah Yusuf Ali's translation of the Quran. The court extolled the conditional permission of polygamy with mandatory rights of perfect equality and equitable justice meted out to all wives, which is deemed by Quran not possible by the man even if it is his ardent desire. Therefore, the Muslim male has been ordered to content with one. The High Court noted that Islamic provisions insist on equitable treatment of wives in a polygamous marriage. The court was of the view that equitability was the crux of the problem of polygamy in Islamic parlance. The court visualized the ground justifying the case of polygamy when it observed, there may be situations as existed in Arabia at the relevant time that wives may be able to feel contentment, security and safety under one husband when there are no enough male persons to offer them such companionship separately. There may be situations where on account of compulsions, women may be able to accommodate and tolerate more than one under the umbrella of marriage satisfactorily. Then and then can only in such case polygamous marriage may be permitted. The High Court asserted that the polygamous life is not a life with dignity, it is a life of perpetual agony and suffering. In this perspective, the court pleaded the constitutional test for the validity of the provision relating to polygamy. It explained the polygamy is permitted, tolerated, accepted and enforced by Indian courts only because the Muslim Personal Law Shariat Act 1937 mandates that the Muslim personal law, that is Shariat, which permits polygamy has to be followed by the Indian courts. In that view of the matter, the High Court advised that the permitting polygamy may also have to pass the test of constitutionality under Article 13 of the Constitution of India. In this case, the High Court left this issue unresolved as it was not called upon to undertake that question with a reference to the Shariat Act. However, it lamented on this situation and expressed its anguish, holding that the courts also, despite the dynamic interpretation of Article 21, have not been called upon to, or at least they have not been embarked so far on that course to decide whether polygamy permitted or tolerated by Indian law offends the fundamental rights to a Muslim woman. The High Court attempted to awake public opinion and judicial conscience and questioned how long can the Parliament and judiciary avoid their duty or obligation to tackle this bull by horns. This commandment of the Holy Quran shall be seen in the context of the pre-Islamic Arabian customs, which placed no restriction as to the number of wives. Islam limited the number to 4 and presented monogamy as an ideal form. But Islam, claiming to be the universal religion having worldwide mission, had to look into the requirements of all ages, circumstances, countries and civilizations. There are certain ordinances in the codes of Islam which shall be looked upon as auxiliary or remedial to meet the contingency of place and time, and the code lays down proper restrictions as to their use. There are certain factors under which polygamy becomes inevitable. Individual factors. In the case of wife's barrenness, perpetual illness, unsuitability for cohabitation, etc., the alternatives available to a man of monogamous society are: number 1, either to take the action of divorcing the wife, or number 2, to wait that far off eventuality of the death of the wife, or number 3, to abandon the hope of an issue and desire of cohabitation. Could not we prefer to take a second wife instead of torturing ourselves or leaving a hopeless wife? So, polygamy in Islam is only a remedy which comes into play when an emergency warrants or an opportunity arises. From the above discussion, we conclude that Muslim marriages do not require any ceremonial solemnization, only legal requirements are required. The marriages have been classified into valid, irregular and void. The category of irregular marriage is that where the prohibition is lifted with the passage of time or on some other contingency. The children of such marriages are legitimate. So far as valid marriages are concerned, Muslim law gives detail about the rights and obligations of the husband and wife, enforceable before courts. One more significant feature of Muslim matrimonial law is that it allows an agreement between the spouses where they can lay down special terms and conditions to regulate their marital life. Further provisions have been laid down to meet a situation where one of the spouses leaves the company of other without a reasonable cause. Dear student, that was all about today's lecture that we discussed marriage and matrimonial rights. Hope you have understood it well. We shall meet again with new topic. Till then, take care of yourself. Goodbye.